Good morning. It's Monday, August 5th, and I have some very good news right now. And this deals with the case against Donald Trump, the January 6th case. The one that has sort of been delayed back and forth because of the actions of the Supreme Court and because of the actions of alien cannon. But this case could still blow up before the election. In spite of Donald Trump's wishful thinking, special counsel Jack Smith's case against him for election interference is not completely dead. In fact, the case is now finally back in the hands of a judge who actually knows how to try a criminal case. Judge Chutkan, who is a former public defender, will decide the next stage of the case in an evidentiary hearing that could amount to a mini-trial of the case against former President Trump. That mini-trial could and should occur before the election. And Judge Chutkan is not wasting any time. Now, Judge Chutkan, a former public defender, will decide whether the next stage of the case will be an evidentiary hearing that could amount to a mini-trial of the case against the former president. And that mini-trial could and should occur before the election. Because the Supreme Court took a slow roll in its immunity decision, the case was sent back to the D.C. Circuit Court of Appeal, which immediately issued its mandate sending the case right to Judge Chutkan on the very same day. So they're not screwing around. They want this case up in front of the public eye way before the election. Now, the High Court, the Supreme Court, had the opportunity to decide this case in December, but it pissed around, putzed around, and did not make its decision until this summer. Wasted 6 months of time. And not only did the court's decision make it impossible to try Trump before the election, but the conservative majority protected Trump. They shielded Trump and future presidents because of their near absolute immunity decision. And they made the evidentiary process for bringing cases against the president a legal labyrinth that had to be carefully constructed and take enormous amounts of time and effort. Now, here's an amazing piece of information for all of you out there. The Supreme Court does not have one justice on it that ever tried a criminal case. They don't have any experience in the world of criminality. And Justice Neil Gorsuch promised to do an oral argument that will be a writing for the ages. How can an inexperienced group of people be responsible for such major activities that go on without having a broad background in the law? So I think it's a big mistake when we assign members of the Supreme Court and we haven't done our homework on whether or not these people have the ultimate amount of experience to be on the greatest court in the country. I was shocked when I heard that information. So now, because of the Supreme Court's actions and its protective wording in the case against Donald Trump, Jack Smith now has to revamp his case. He has to hammer out what must be done to figure out what parts of his indictment will survive. And Judge Chutkan has ordered Jack Smith and Trump's legal team to confer with each other prior to August 9th and to prepare for a status conference on August 16th, which will determine the next steps in this case. So Judge Chutkan is not screwing around. She's going to get this thing done before the election. And I am sure that the Trump team is going to do everything possible to delay, and delay. But Judge Chutkan is not screwing around. She had a choice of whether to have the lawyers fight it out on paper or to stand up and combine the paper with live witness testimony. And she is going with the live witness testimony. Because if you have to spend time writing all these things down, nothing is going to get done. Now, some famous law professor has said this type of hearing is routinely done in connection with federal criminal cases on a wide range of issues, most commonly motions to suppress evidence. And Jack Smith could call to the stand many of the same witnesses he presumably would call during the trial itself. And the White House counsels who may have refused to participate in such actions and advises against its illegality. Those Trump officials who refused to go along with the fake elector scheme and a vice president who rejected the idea that he had the authority to refuse or even delay the counting of the electoral votes. All of that can come out in front of Judge Chutkan. So in my mind, we need this public hearing with witnesses. It would be a great service to the American public because it would allow a full display of just what actions Trump is alleged to have done to interfere with the peaceful transfer of powers. Voters deserve to know this before the election, and but for the actions of the Supreme Court, voters might have also learned whether they would be voting for a twice convicted felon to be president of the United States. So this is no simple situation that has to be resolved. And Jack Smith and Judge Chutkan are trying their hardest to get this thing properly resolved and put in front of the American people. But on the other side, the Trump team does not want the truth to come out. And they will do everything in their power to delay, and get this thing halted until the election is run. So that's what we're faced with. The possibility of a felon becoming president of the United States. Wouldn't that be great? Have a great day. Bye. Bye.